Today we're here to talk about some more principles of employment law. So last time we spoke about the National Employment Standards, which is the bare minimum rights that are set out in the Fair Work Act. And today we're going to be talking about awards, which is sort of the next level up from the National Employment Standards. So I'm Leon Harper, and this is my fellow lawyer, Tian Crowther. We're lawyers at Young Workers Centre, which is a free community legal centre that provides advice and representation to young people about their rights in employment law in Victoria. So here we have the same pyramid that we showed in our previous presentation, which has the different sources of employment law in Australia. So at the very bottom, we've got the Fair Work Act, which has its national employment standards. The national employment standards are the bare minimum rights that every worker or almost every worker in Australia has. The next level that's up from there is awards and enterprise bargaining agreements. At the very top, there's contracts. So today we're going to be talking about awards. Awards are generally better than the national employment standards, but enterprise bargaining agreements and contracts may be superior to awards. They might have some terms that are a bit better, like more pay, better leave conditions. They might have some more workplace or industry specific terms.
Awesome, thanks, Leon. So what is an award? It is a source of legal rights that covers a minimum safety net for workers in Australia, and each award will cover either a specific industry or a specific occupation, or sometimes both. There are awards that cover similar industries, and an example of that might be the Restaurant Award, as well as the Hospitality Industry Award. There are specific clauses in each award that might differentiate each of them, so when they might come into operation. So in that example, a restaurant, most people know what a restaurant is, but a restaurant that operates in connection with a hotel or as part of a hotel is actually covered by the Hospitality Industry Award. So each award will have these fun clauses that might differentiate them from each other. As I said, they provide minimum standards and entitlements. So that's things like rates of pay. It's also things like when you might take your breaks, when you might get penalty rates for working on the weekend, what shift work is. Sometimes they'll also establish what it means to be a full-time and a part-time employee. These kind of minimum standards and entitlements also relate to which industry you're working in. So if you're working as a nurse, for example, shift work might mean something different to if you're working in a factory. When we talk about minimum standards, we mean just that. So as Leon said, awards are slightly better than the NES, but they create a floor for workers in each industry. So that means that the pay rate that workers should receive as part of their award is the absolute bare minimum that they must receive lawfully. And that is sort of connected to the concept of a living wage. That's to enable them to do things like buy food or pay rent or look after their family, and award rates of pay increase each year for that reason. That's why at the Young Workers Centre we say that if you've not been paid your award rates, it's wage theft, because your ability to live has actually been substantially diminished. The way that awards work, as Leon said, is that they need to provide better conditions than the NES, being the National Employment Standards, but they can be superseded. So you can have an award not apply to you if you have an employment contract or if you have an enterprise bargained agreement. An employment contract is something that you might agree to with your employer as an individual, so on a one-on-one basis. And for an employment contract to be valid, it would need to provide for generally better conditions than the award. An enterprise bargain agreement is an agreement that an employer would agree to with all of their workers. And again, it's for the purposes of providing better conditions than the award. Unless you have an enterprise bargained agreement or a private contract agree to your employment, an award will apply to your employment. There's always an award for you. We get plenty of workers come to us that says There is no award for our workplace, and that's not correct. It might just be a matter of finding it. All right, so just a quick bit of history about where awards have come from. They're a uniquely Australian thing in our law. In the 1850s and 1860s, across industrializing nations, so by that I mean places like the United Kingdom, the United States and Australia, trade unions began to form across the world, and they formed around specific issues. Trade unions are a collection of workers, all self-representing, and they were formed around this time about issues relevant to the industries of the time. So one of my favourite old unions, for example, is the Carriage Makers Union. There's also the Felt Hatters Union, the Candle Makers Union, the Tailoresses Union. They've all now been amalgamated, so they've joined in with other unions to form part of bigger unions. But these were all unions that existed at the time, fighting for the rights of the workers that they were representing. Now, as I said, these unions joined together in an industry to ask for improvements to the minimum standards. If you think about it, at the time, you had people going into coal mines, dying on the job, that kind of thing. So it's very important that workers were able to join together to say that they wanted to be safe at work, but they also wanted to be paid a rate that could help them provide for their family. And that's the sort of thing that unions did, and that process is called negotiation, and that's ongoing and things that unions continue to do to this day. In 1871, the Trade Union Act of the United Kingdom was passed, and this made this process of negotiation lawful. It also regulated the process because we in Australia at the time had British colonies, so the law applied to the British colonies here in Australia, so that act also applied to us here as well. And so, yeah, as I said, it regulated the process of bargaining. We've got up there, just to bring to your attention, an interesting strike that happened at the time that kind of formed the foundation for a lot of the rights and entitlements that we have today, and that's the maritime strike of the 1890s. This is really interesting because it started with a particular group of workers working on ships. The officers, who were slightly, I guess, better paid and more respected than some of the other workers who worked in the maritime industry. It started because they wanted to form a union, and the employers, so the people who owned the ships, didn't want them to, because they'd be standing up with some of their working class, I guess, fellow employees. So this led to a strike, and then that strike led to other, what we would call solidarity strikes. So wharf workers went on strike, shearers went on strike, even people, workers in New Zealand went on strike. Even though it started in Melbourne, it quickly spread to Sydney and then went all across the country. And as I say, went over to New Zealand as well. This pushed along the concept of wages that should be relevant across an industry and to a particular group of workers. Then in 1904, after all this industrial activity was happening, the Australian government, the newly formed Australian government, introduced the Conciliation and Arbitration Act. This established a kind of court-like process to formalise these kinds of negotiations, and also to provide an arbiter, which is sort of like an independent person, almost like a judge, to help guide these negotiations. So that was kind of the purpose of that, was to regulate some of these strikes, stop them from happening, see if these negotiations could happen without bringing certain parts of the economy to a standstill. Of course, plenty of industrial activity kept going throughout this time as well. And then after this act was introduced, it led to a really important case that was in 1907, called the Sunshine Harvester case. This case is fundamental. It underpins much of Australian workplace law today, and that's because it established some of the legal concepts around what a livable wage is. Now, a livable wage, if you read the Sunshine Harvester case, it says that it's for a man to be able to provide for his wife and his 3 children, and for them to live in frugal comfort, which is quite interesting terminology. Frugal comfort at the time meant that the man could provide all the necessities of life for his family, plus also be able to take them to the pictures, to the movies once a month, and also for them to be able to provide or afford a Sunday roast each week as well. So obviously, this idea is a little bit outdated. Obviously, women work today, but kind of some of the concepts are still relevant. So that idea that your wage should be able to provide you enough money so that you can meet all the costs of life, but also be able to have a little bit of enjoyment on top of that as well. So after this and throughout Federation was a process of bargaining, so unions or workers joining together to speak with their employer about what their conditions should be increased, and this is kind of where the award system came from. So before the 1980s, there was a number of specific awards that came about as a result of employees and employers bargaining through the conciliation and arbitration process. And this led to specific awards for kind of, I like to think about them almost as like sub-industries. So instead of what today might be the Communications Award, there was the Commercial Radio Announcers Award. There was also the Potato Crisp Makers Award, which I think is great, whereas that today might fit in under the Food Manufacturers Award, and same for the Mushroom Industry Employees Award. So all these kind of sub-specific industries of groups of workers got together and they bargained collectively for awards to set these kind of proactive minimum conditions. Once we sort of hit the 1970s, 80s and 90s, that idea of bargaining was moved away from industries in the kind of award sense, and then moved more towards what we would call specific enterprise bargaining. So that means bargaining that took place for workers at a specific business with their specific employer. And this is where the idea of enterprise agreements took up prominence, and they sort of became the dominant means that unions used to improve minimum wages and conditions. So that sort of became the norm from the 1980s onwards. Enterprise bargaining is something that still continues to this day in a very similar, although slightly different format. And then we had in 2005 a piece of legislation that was brought in by the then Prime Minister John Howard, and that piece of legislation is called Work Choices. Work Choices did a range of things, but one of the things it did was introduce Australian workplace agreements to sort of replace awards as setting the minimum for workers. So AWAs, as they were called, they were one-on-one agreements with the employer and the individual employee. And this made it really difficult for employees to improve their overall condition. If you're not getting the same pay as your fellow worker who's doing the same job as you, it can be really hard to ask for a pay rise, for example, if the law says that you have to have that conversation with your boss on your own. So AWAs were a bit problematic, I suppose we would say, from our perspective. They made it really hard for workers to have those kind of livable wage conditions and to be able to enforce the minimum standards that this concept that awards throughout history had tried to engender. There was a change of government in 2007, and so Work Choices as legislation was scrapped shortly after that. And then the Fair Work Act was introduced, This is the act that we work with today. Leon and I know it probably too well, and it brought back the idea of awards. Today they're called modern awards, just to differentiate them from the history. And this system has since amalgamated many of the old awards into more broad industry awards. Those are the sorts of things that I talked about before: the restaurant industry award, the food manufacturing industry award, the construction industry award, slightly more broader than what they had before. The Fair Work Act also brought in the national employment standards. As Leon has already spoken to, the national employment standards apply to every worker, no matter what. Your award applies to you if you're in that industry or if you're working in that occupation. And this is the system under which we operate today. This is where I throw it back to Leon.
Thanks, Tian. So all of that is really important to understand exactly what modern awards are and why we have them. The purpose of the modern award system is to balance the need for workers to have protections and minimum safety nets while also creating a system that is relatively simple enough for everyone to navigate. So for both bosses and workers to be able to work out, what do I have to pay? What do I have to provide? So all of that, sometimes extremely action-packed history is how we've gotten to this point. Modern awards, in a legal sense, are created by the Fair Work Act to cover specific industries. Each modern award will define one of its first clauses, one of the first sort of paragraphs in it, will define what it considers to be that industry. So sometimes these are pretty broad. The Building and Construction General On-Site Award covers a lot of what you would think about finding on a construction site. So bricklayers, builders, carpenters, all that kind of thing. Cemetery Industry Award, much narrower, basically just applies to people who work in cemeteries, and depending on what kind of work they're doing, it might not even apply to them. People who maintain gardens in cemeteries will actually often come under another award anyway. Tian's spoken about the Restaurant and Hospitality Awards. So sometimes awards will seem to have areas where, maybe multiple awards might apply. Or sometimes you might have a bit of, a pretty strange job and it's not clear if any award at all applies. But most workers in Australia are covered by a modern award, even if there's an enterprise bargaining agreement or a contract in the workplace that provides better conditions. It's still important to know what your award is. The rules for how awards are created and amended or changed is all contained within the Fair Work Act. So the Fair Work Act basically lays out all the rules for like what goes into an award, what awards can and can't include, how do we change them, what processes do we go through to change them. Now, whenever an award is going to be changed, and this sort of goes back to the history that Tiana was just talking about, the Fair Work Commission, who manage all of this, will seek comments from various groups. So they'll talk to unions, they'll talk to employer groups, they'll talk to other interested parties, and based on all of that, they'll look at, okay, what should the terms of the award be? How should this particular wording be applied? Who should get this allowance when? How much should this group of people be paid? And the Fair Work Act is the architecture and the rules that sets all of that up. So all awards will contain certain things. The awards are set up so that they read in a fairly uniform and similar way. This is also something that the Fair Work Commission is continuing to work on. Some of them are still pretty complicated, unfortunately. So common terms that we'll see in all awards will be minimum rates of pay. This is the big one. This is the one that most people are concerned about. The reason that most of us do a job is because as much as we like it, we do also want to get paid. So we want to find out what's the minimum that we should be getting paid. Now, in most, if not all industries, it won't just be one rate of pay. So there might be, for example, a rate of pay that you get if you work during the day. There might be a different rate of pay for work done on the evening or done on weekends or public holidays. There'll also be different rates of pay for different classifications. So what a classification is, that's the term that's used throughout all different awards, is basically exactly what kind of job you do. So let's take someone who works at Woolworths, for example. You might have someone who's working on the checkout or working during stock take or doing night fill. They will be at one classification under the award. then someone who is their, their immediate on-shift manager or team leader, the manager on duty, they'll be at another level under the award. And then someone who might be the ultimate owner of the store will be under a different level again. That's just one example, and that's a very simple example. Woolworths is one of many employers that's actually generally covered by enterprise bargaining agreements. But these kinds of similar structures exist in lots of places. If you think about, you might have worked or know people who've worked at McDonald's or KFC or at one of the supermarkets. A lot of them will have these similar structures. And those kinds of structures are really adapted and set out from what's in the award. So sometimes it can be a bit complicated to work out exactly what level someone is under the award, and sometimes it'll be really, really straightforward. But that also goes into how much you're paid. The idea being that if you're someone who's in a higher position and has more responsibility, maybe someone who had to do special training, like had to do an apprenticeship or something like that to do the work that they're doing, that you should be paid at a higher level of pay to reflect that. Another kind of rate of pay will be penalty and overtime rates. So penalty rates usually refers to what I mentioned earlier, working on the weekend, working on public holidays, maybe working on evenings in the case of some awards, or doing night shifts. Overtime rates will be where you're working, the technical term is in excess of your ordinary hours. So for most people, that's going to mean working more than 38 hours a week. The idea being that people should not generally have to work more than 38 hours, and that if they do have to, the employer should pay them something extra to make up for the inconvenience and for the strain that's putting on them. The last thing that's in most awards is allowances. So allowances will be pretty different depending on the industry. And this is an example of where awards can be really, really useful to reflect things that are happening in the industry. So for example, you might have, if you're working especially at a fast food place or at a restaurant, you might have to have a special uniform that you have to take home and wash. For that, you might be getting a laundry allowance. Now, if you're an electrician or a plumber, you might have to travel a lot for your work. And so for that, you might get a travel allowance for, the inconvenience of having to drive your own car all around and having to carry things in it. Different allowances will be under different awards, and that's one of the things that the Fair Work Commission considers when they're working out what terms to put in awards. And they take guidance from unions and other parties that are in that particular industry to know what should be fair. For example, if you're, working in an industry and in a job where you don't have to travel very much, you probably don't need a travel allowance. But if you have to travel a lot, you really need one. So awards will also change over time. They won't remain static. There's three main sorts of ways that awards will change. Every financial year, at least a little bit of the award will change, because generally your rate of pay will go up with each financial year. This got a little bit tricky during the COVID-19 pandemic, where the Fair Work Commission decided to delay some of the changes to awards. But for the most part, every financial year, the rate that everyone is paid will go up slightly through complicated forces around inflation and all this economic stuff that personally I'm glad I don't have to think about. New clauses might be added in. So again, COVID gave us a pretty good example of that. To a lot of awards, different provisions were added in to reflect how that industry in particular might deal with COVID-19 and might deal with, for example, people having to take more unpaid leave or taking more annual leave than normal during the lockdowns. There also might be a case where new clauses are added in to reflect things that society has decided are really important. So as we saw from the history that Chan was talking about, this is awards changed, society's values changed. Back 100 years ago, the idea was that it was only men going out and working and they were supporting a wife and 3 kids at home. Now, thankfully, everyone is able to work and everyone's able to pursue their careers, and lots of people might not even choose to have kids. So new clauses might be added in and things might be changed around to reflect that our values are changing as well. So one recent thing that's been added into awards has been unpaid family and domestic violence leave. So the recognition that someone who's going through family and domestic violence might need to take some time off work to deal with that, and that's an expectation that we as a society have, that they should be allowed to do that. So other clauses can be added in. Sometimes it can be other industry specific types of clauses. Sometimes they'll be added into many awards at the same time. Now, ultimately, these awards are amended by the Fair Work Commission. As I've said, they take guidance from a lot of interested groups, including unions and employer associations, and they'll also be reacting to directions from Parliament and all sorts of different interests. Finally, awards might be changed to clarify or make things a little bit clearer. Lots of these documents were drafted by lawyers, maybe lawyers who are not as used to talking to the rest of us. Some of them can be really complicated to read, and a project that the Fair Work Commission has been going through is trying to make these a bit easier to read. So sometimes they might write something down that they think, right, it is so clear that this is what this means. Anyone could read that and tell, obviously, we mean that, they get $5 if someone drops a cup at work or something like that. And then you might suddenly have a court case that gets all the way to the High Court, and it's extremely clear to everyone that they had no idea what that meant. So sometimes they'll fix up awards just to be like, right, okay, see that actually needs to be changed, let's do it. So most workers in Australia are covered by awards. The main times in which you wouldn't be covered by awards would be if you're what's called an award-free employee, which is not something that we generally see very often. That would be people in very specialised occupations. If you're working under an enterprise bargaining agreement, which is an agreement between all the workers at a different workplace and their employer, then the enterprise bargaining agreement would apply where it's better than the award, but there might still be cases where parts of the award might apply, or where we would at least want to know what the award is. The minimum wage for most workers is set in an award, and lots of workers are paid under that award wage, so they're only paid the bare minimum that they're meant to be paid. Obviously, we would prefer it, and we think that it's a minimum, so it would be great if people have paid more than the minimum, but it's really important to keep in mind that it is the minimum. Most wage theft cases that Tian and I see, and we see a lot of them unfortunately, are related to awards. So that might be what award applies. We call that coverage. So which award has coverage of a workplace. Classification. So the job that someone's doing, how does that fit into the different levels of classification that's in the award? And whether certain clauses apply. So, things like penalty rates, things like allowances of that kind of thing, whether that applies in this specific purpose. The award system is really, really important in that it, sets out to cover all workers in Australia and make sure that everyone is getting the pay and the conditions that they're entitled to. But sometimes it can get complex and things can be a bit unclear. So that's a lot of the cases that we have, is that kind of thing, trying to sort of take something and look at it and be like, okay, how does this actually work in reality though?
Thanks, Leon. So yeah, the main takeaway from this is that awards set minimum standards. Some people may be paid more than the minimum in their award, and we think that should be the most common. As we said earlier, awards set rates that mean that you can do the bare minimum to interact in society. There are also a range of reasons why that has actually not been the case so much lately. While we do have a minimum wage in this country, there's a huge rise in casual work, for example. People who aren't working full time, they aren't getting 38 hours of work, and they'd like more hours, but they can't get them. So that hourly rate is not enough for them to be able to provide for their family. So this kind of concept of a living wage has been diminished a little bit over the last sort of couple of decades. So I guess that's why we would say that it should be the norm that people are paid more than the minimum standard set out in the award. Unfortunately, it is a bit too common that people are paid less than the minimum standards in the award. And that's the sort of thing that Leon and I do all the time as part of working at the Young Workers Centre. And the reason why that becomes a legal issue is because it's actually unlawful to be paid less than the minimum standard set out in the award. Your award rates of pay might vary based on what your classification is, as Leon said, but pay can also differentiate basically based on a range of social factors. So things like how society values them. We look at, you might have seen in the news recently, aged care workers. They're really important, but unfortunately they're paid really lowly. So there could be a problem there with how we actually value aged care workers, for example. There also might be a higher rate of pay if we think about how important it is that that kind of work exists. So I have a friend who's a software engineer and he's paid really well. And that kind of work is really important for keeping us going, pushing the technology along. So that's the sort of thing that might impact your rate of pay being higher. And then another thing that might impact your rate of pay being higher is things like how dangerous it is to do your work. So are you working with electrics, for example? Are you working on roofs? Are you dealing with dangerous social situations? So things like police and people like that. That also might go into how much you're paid. But overall, I think our message today is that awards are really important. They set out the minimum standards relevant to your rate of pay and your work. You must be paid in compliance with an award, and that might be different depending on what you do or what industry you are in. And that it's really important that we think about what the concept of a living wage is. Are awards keeping up with that? And what's the best way to make progress? Another thing that we would say is that workers getting together and bargaining with their employer for higher rates of pay is one of the best ways to push forward increases to the minimum standards and also increases to a living wage. That's it from us today. And yeah, I hope you enjoyed this overview of the award system.